The room goes quiet the moment the name appears, not shouted, not emphasized, just sitting there in black and white, buried inside thousands of pages that were supposedly processed, filtered, and cleaned up. Pages released under claims of transparency, yet somehow still designed to keep certain people protected. For years, survivors have waited for this moment. For years, powerful figures insisted that nothing linked them directly to Jeffrey Epstein once real scrutiny began. And for years, the promise was the same. When the files come out, the truth will finally settle it. Now, the files are coming out, and suddenly there's a scramble, because something went wrong. A redaction that didn't happen, a name that slipped through, and a legal expert has now gone on record saying this wasn't an accident, it was a miscalculation, a maneuver meant to steer attention away from where it wasn't supposed to land. Before we walk through what that maneuver was and why it's already failing, make sure you're following the channel and drop a like if you think the full truth should never be buried for anyone's convenience. The focus right now isn't rumor or speculation. It's the release of tens of thousands of Epstein-related documents that came out after a Republican-led committee dumped roughly 20,000 pages into the public record. That release happened fast. But what caught legal experts off guard was what wasn't removed and what the law actually allows redactors to hide. Here's where the explanation becomes critical. Because embarrassment is not a valid reason to protect a name under the law that governs these disclosures. And that single fact changes everything. A former prosecutor was asked directly whether it was shocking that certain references survived the redaction process, and his answer exposed the flaw that now has the administration on the defensive.
Dave, if we go back to when the Republican-led committee dumped those 20,000 documents, it came hours after Democrats leaked 3 emails that mentioned Donald Trump's name. Does it surprise you that redactions slipped through the cracks and what should have gone into the redaction process?
Alex, the key is to redact the names of the victims and also to redact any child pornography or other images that the public should not see. And so that's it. That's it. I mean, then there are issues over whether the alleged co-conspirators should have their names redacted because there may be other court orders. When Ghislaine Maxwell went to trial, there were apparently potential co-conspirators who went to the court to say, my name should never be released as part of this investigation. And so you have to work through that. But that means that almost every other document should be released. And so that's why the redactions should be few and far between. And the Epstein Transparency Act makes it clear that you cannot redact any documents or any names because of embarrassment. So it should be game on. And I'm not surprised that the administration wants to drag its feet.
That distinction, victim protection versus embarrassment protection, is the line everything hinges on. And once that line is understood, a pattern begins to emerge. Because the same administration now insisting on careful handling is already shifting focus away from the documents that actually contain investigative detail and toward a different set of records entirely. Why that shift matters and whose name it helps keep out of headlines is where this story is heading next. The shift happened almost immediately. As soon as attention landed on the files themselves, the records sitting inside the Department of Justice, messaging began to pivot. New headlines, new framing, a sudden emphasis on grand jury material instead of investigative documents. To most people, it sounds like the same thing. Legally, it isn't. And that difference is the shield. The grand jury records are narrow, procedural, limited to whether prosecutors had enough to indict at a specific moment. The investigative files are broader. Emails, witness statements, background evidence, internal communications. That's where patterns live. That's where names repeat. That's where relationships stop being deniable. And importantly, those investigative files are in DOJ possession. That's why survivors aren't asking politely anymore. They already endured years of silence, sealed settlements, and courtrooms that treated their trauma like a liability. Now, after Congress passed the law explicitly saying names cannot be hidden simply to avoid embarrassment, they're watching the same avoidance tactics reappear, just dressed up as legal caution. A former prosecutor laid out exactly how deep that failure cuts, because while officials talk about protecting victims, survivors are being forced to relive the harm while the public conversation is carefully redirected away from accountability.
So the filings, Dave, they come in Attorney General Pam Bondi's latest push to release grand jury evidence from the Epstein case and the Maxwell trial. One survivor is quoted as saying she was unable to mentally and emotionally function or sleep. Another said the situation was, quote, very scary. And lawyers said transparency cannot come at the expense of privacy, safety, and protection of those who were abused. But the harm is already being done. So what duty does DOJ now owe survivors?
You know, the survivors have been let down by so many people, politicians over the years, prosecutors over the years. And so the least they could do is to work with them to make sure that they're part of the process. And they're doing that when they go to the judges about the release of grand jury documents. They're working with survivors. That's a positive step. But the survivors don't want the names of the co-conspirators to be redacted. They don't want Donald Trump's name to be redacted. They want the names of all these people out there who did this to them, because they're not going to be able to do it on their own. They're worried about lawsuits. They're worried about physical threats. They need the government to stand up for them.
That last line explains everything. This isn't about curiosity. It's about power imbalance. Survivors don't have the resources to fight wealthy, connected figures one lawsuit at a time. Exposure isn't vengeance. It's protection. It's the only leverage left when the system has failed repeatedly. So when DOJ leadership emphasizes releasing grand jury records that notoriously omit many names, it raises a critical question. Why push hardest for the one set of documents least likely to implicate anyone new? The answer came next. Because timing matters, deadlines matter, and courts, not politicians, control what happens once those deadlines pass. A judge has now ordered DOJ to explain exactly what is being withheld under a 2019 protective order and why. Another judge overseeing the Maxwell trial has demanded similar clarity. These aren't symbolic gestures. They force disclosure or force justification. And it's here that the legal expert exposed the strategy.
So the judge in the Epstein case gave DOJ until noon Monday to provide a detailed description of materials subject to that 2019 protective order. The judge in the Maxwell trial asked for similar details and set deadlines of, I think it's December 10th. Is Bondi now hoping the court might give her some kind of cover to not release all the files in spite of the law that Trump signed?
Well, it is interesting because the law doesn't specifically say grand jury documents. The law talks about documents in the possession of the DOJ. Well, the grand jury records are not in the government's possession necessarily. They are in the court's possession, and the court has said we are not giving them up. Now, there's a new law in place, this Epstein Transparency Act, that does create a window to allow the release of these documents. But it's going to be up to the federal judges. And that's why the government is working with survivors to try to release them. And you may be wondering, Alex, for a government that has been reluctant to reveal the Epstein files, why are they pushing for the grand jury records to be released? And the reason is because they know that Trump's name is not in there when it comes to investigative files about Ghislaine Maxwell that led to her indictment. Same thing for Jeffrey Epstein. That's why they wanted these grand jury records released before the Epstein Transparency Act had ever been passed. So they're going to keep pushing that. But the key here is the files. The files are different than the grand jury records. They're going to push for the release of the grand jury records. But don't forget what's in over here in door B. That's the stuff that everyone wants.
Yeah, I think they're hoping that Americans don't, distinguish between the two, and they're not listening to you explain what the difference is.
That's the pattern. Redirect transparency efforts toward records that omit damaging names, claim compliance, declare the matter settled, and hope the public never notices what remained locked away. But there's a problem. Judges understand the difference. Survivors understand the difference. And now enough of the public understands it too. The question is no longer whether files will be released. It's whether the attempt to substitute one set of records for another will hold long enough to matter. Because once the distinction collapses, the strategy goes with it. It all circles back to intent. Because this was never about confusion. It was never about ambiguity in the law. And it certainly wasn't about protecting survivors. The law was explicit. The deadlines were explicit, and the distinction between grand jury records and investigative files could not be clear to anyone operating in good faith. What changed was exposure. Once Donald Trump's name surfaced, once it appeared in documents released despite Republican control of the process, the response wasn't transparency. It was containment. A pivot. a calculated narrowing of what disclosure would mean going forward. That's the fatal flaw in the scheme. The Epstein Transparency Act does not allow names to be hidden for reputational harm. It does not permit selective disclosure that favors the powerful, and it does not grant DOJ the authority to redefine compliance by swapping documents at the last second. What it does is force a reckoning, and the reckoning no longer lives on cable panels or social media threads. It lives in courtrooms, with judges who are now demanding itemized explanations for what's being withheld and under what authority. That's where this effort collapses. Because once DOJ is forced to describe the contents of those protective orders, once they must explain, line by line, why specific investigative materials remain sealed, the illusion of cooperation ends. The files either qualify for release under the law, or they don't, and embarrassment is no longer a valid excuse. For Trump, that's the problem he can't bluster his way out of. The grand jury records he wants released are safe. They're narrow. They omit context, they omit relationships, they omit the very connective tissue that survivors have been pointing to for years. The files DOJ has been slow-walking are different. They tell stories across time. They show who knew whom, who stayed in touch, who resurfaced repeatedly. They explain why survivors keep saying the same names and why those names were once treated as untouchable. And this time those survivors are no longer alone. They're supported by statute, by judges, and by a growing recognition that the old strategy, delay, distract, deny, only works in silence. The silence is gone. Trump wanted the Epstein story buried under procedure. He wanted Americans to believe that releasing something meant releasing everything, and he wanted to outrun the truth long enough for attention to drift. Instead, his own maneuver drew a line straight to what matters most. Door A was never the real story. Door B is. And it's the one the law was written to open. Because justice delayed is not neutrality, and transparency delayed is not transparency at all. It's obstruction with better branding. If you care about holding powerful people accountable, follow this channel, turn on notifications, share this video, and leave a comment with your thoughts on who still hasn't been named and why.